Hello and welcome once again to this time to the fourth episode of the Handbook to Israeli Legal Reform, where we try to dig to the best of our abilities to the bits and bytes of the reform attended, trying to explain what are the motives, what are the ends of the reform that the Israeli current government is trying to apply and to legislate in the Israeli parliament. Now, one of the most intense centers of clash between the two parties that discuss this issue is the override clause. And this is one of those elements that are extremely complicated to explain to American audiences. Now, I know that the majority of my viewers are American Jews. And given that, it means that at least 40% of my viewers are American Jewish lawyers, because this is what you do over there. So the point is that in the American system there is no equivalent to the override clause. This might seem a bit pretentious. They might seem a bit subversive to suggest an override clause. What the override clause basically means. It means that if the Supreme Court decides to deem legislation as unconstitutional, the Parliament has the right to override this decision and to say that even though the court decided it goes against the Constitution, it will still be valid. Now, this line of thinking, in the view of an American jurist, well, it's a blasphemy. It's something that cannot even be brought up to mind. To say that a principle will still be valid and a law will still be intact even though it contradicts the Constitution, it's something that American jurists, American lawyers, American judges simply cannot comprehend. But the first thing that needs to be understood when discussing the issue of the override clause is the fact that it does exist in other constitutional democracies. Canada is the most significant example for it. When in the 1980s, when the Canadians have framed their charter, amended their constitution to include a human rights charter, they embedded within it the right of the parliament to override a decision of the court to deem legislation as constitutional. This is a mechanism that does exist in other democracies and operates as a balancing mechanism against the independence of the court once they cross certain lines. In Israel, we have a very problematic history of the court overrides legislation in general, even though that we don't even have a constitution. Now, the problem with not having a constitution was explained in the first video of the series, and we will put a link below. Over there you can, I do my best to analyze what it's like to try to make constitutional amendments where there is no constitution. Even though there is no constitution in Israel, Israel is the only place in the world when judges can override legislation and deem legislation as unconstitutional while in complete absence of constitution. The UK and New Zealand, the only other two cases of democracies without a written constitution, simply do not have a mechanism of judicial review over legislations. Over there, judges cannot deem a law as unconstitutional. And there is a great sense in it, because if there is no constitution to rely on, how can one say that the legislation is unconstitutional? Yet here we do have it. And the judges did it over and over again in a manner that on one hand called for an immense public criticism and public scrutiny towards those judges. On the other hand, the hands of the legislators that were democratically elected to apply policies dictated by the public in a democratic manner, their hands were tied against judges that have decided that such policies cannot be implemented. I'll give you an example. And the example go to immigration policy. Now, immigration policy is a heated debate in every democratic country, and this is one of those issues that deviates between left and right in each and every democratic country that you can think of. To what extent does a democratic country give right to aliens to be absorbed in it and become citizens? And those decisions in democracies are being made democratically. The human rights, other than civil rights, of those immigrants or those aliens needs to be very carefully decided. And they are being decided in a democratic manner via legislation. This is the way it is. Now, one can completely understand that there will be certain cases where the infringements of rights of legal or illegal immigrants calls for judicial review. But this was not the case in Israel. The original legislation said that once a person that entered Israel illegally by crossing by foot the open border that used to be in existence between Israel and Egypt, he will be not deported from Israel, but he will be sent away from the center of Israeli cities to a facility in the Israeli border. This was not jail. They were free to leave. They were only ordered to stay there by night. But because it was so remote, deep in the Negev desert, there was no fear from them to go into Israeli cities. And this is where they had to stay as long as they choose to stay in Israel. They can leave this place anytime they want. But when they do that, they have to do that to the airport and to be deported. Even though their human rights were not infringed, the court still deemed this policy as unconstitutional and overrode the immigration policy that was dictated by the Israeli public to the politicians. Now, a government that cannot decide on its own immigration policy, that cannot decide on its own laws that dictate what will be made with people who cross its border illegally, such government cannot be defined as sovereign. The entity that gets to decide what is going to happen when someone crosses a country's border is the sovereign of this country. This is one of the very definitions. The element of border is what defines a sovereign country. And if you take away the right to decide about immigration policy from the parliament, then the parliament becomes no longer sovereign. The judges are. And this is exactly why the override clause is needed. When a case is brought to a judge in the Supreme Court, they eventually balance between competing rights. This is what they do. And their decision could either be accepted by the Israeli public or not accepted by them. But there must be a mechanism that mediates the fact that a certain decision, that a certain virtue or virtuous decision that was made by judges is not accepted by the Israeli public. This is the override clause. This is why many democracies have decided that in certain cases, a decision of the court, whether legislation is deemed constitutional or unconstitutional, can be reviewed by members of the parliament. Now, an explicit mechanism of this sort does not exist in the United States. But there is another mechanism that is beyond what is written. In 1832, in the case of Worcester versus Georgia, Supreme Justice John Marshall have decided that the Indian Removal Act that was promoted by the Andrew Jackson administration was unconstitutional. But Andrew Jackson completely ignored this decision and famously said that we've heard John Marshall's political opinion, now let's see him enforce it. In 1864, President Abraham Lincoln have decided on administrative custodies for terrorists that acted in Maryland on behalf of the South. Supreme Justice Roger Taney have decided this to be completely illegal, unconstitutional, and legally wise by the letter of the law. He was right. This was indeed unconstitutional. Lincoln did not obey. And it came to the point when Roger Taney sent a platoon of court marshals to take a certain person, a certain person in custody, out of jail by force. And Lincoln sent a platoon of the Northern Army to defend this jail against the platoon of the court. And at the very last second, Roger Taney, decided to give up. The first shot in this conflict between the judiciary and the executive of the United States, the first shot was not taken by anyone because the judge decided to cave in. And this very important incident in American history have decided, or basically have charted the line between the authority of the court to override laws in general and decisions of the executive in even greater manner, and what actually happens. Presidents, from time to time, have the right to disobey the court. This is what they have instead of an override clause. What is currently being offered and suggested by the government of Israel is a very well-defined and very well-stricted right for the parliament to override. It's not something that can just be done. If the court decides that certain legislation is unconstitutional according to the offer at hand, the parliament needs to override it in a special majority. There is dispute about what is the size of the majority, but it can't just be decided in majority of 15 to 10. You must have at least, in the most liberal of suggestion, at least 51% of the members of the Israeli Knesset. Because you need to have a consensus in order to infringe rights in an unconstitutional manner. This is a mechanism that exists in many other places and is currently at hand in Israeli legislation. This is the override clause, and this is why it is so important.